All right, I am joined today by Kyla Lee, who is a lawyer at Acumen Law Group and has become very prominent in Vancouver, especially on social media, for being one of the go-to people for, I guess, vehicle-related crimes, driving under the influence, dangerous driving. She also has a podcast called Driving Law. And correct me if it's a CBC show or you're a CBC panelist weekly
Yes, so
on
weekly.
politics.
Yes.
Yeah, actually, maybe we can talk politics at the end.
Yeah.
It's always closely related to law. But thanks for coming on today.
Thank you for
I don't
having
know
me.
if there's anything else you want to plug that you're involved with. I know you also have a very well viewed TikTok channel.
Yes, I do. It's fun.
Awesome.
Yeah.
Are you concerned about it getting banned? The app, not your channel.
Uh, no, not really. In fact, I'm a little bit hopeful that the US ban does happen and that TikTok
Interesting.
decides to give like more options to Canadian content creators. Because right now, US content creators have a sort of a bigger opportunity on the app than Canadians.
Interesting. Yeah, I had TikTok for a bit. And I found I had to do a lot of like algorithm prompting, going not interested, not interested. And it slowly morphed into what I wanted. And then I just got fed up with social media on my phone and don't have it anymore. But why don't we dive into the topic today, which is driving under the influence. And why don't we start? We got a few questions about the topic, but I'd like to just start with an overview of what actually is driving under the influence.
So in Canada, we don't use the term driving under the influence, but that's what most people know it as. We have the offense of impaired driving, and we have a separate offense for being at or over 80 milligrams of alcohol within 2 hours after ceasing to operate a motor vehicle. So there's sort of two different charges you can get for driving under the influence specifically.
Yeah.
And beyond the federal criminal law, there are also provincial administrative schemes in most provinces and territories that deal with it on an administrative level, whether it's alongside a criminal investigation or in lieu of a criminal investigation.
Yeah. And I want to come back to that procedure because I do have quite a few actual like personal questions about how that all works. But in terms of the two components, I guess, of
Mhm.
impaired driving. So the first is, does it matter what the substance is that is impairing someone?
No, so the criminal code doesn't specify as between alcohol or drugs, or a combination of the two. So you can be impaired by pretty much anything. And drugs doesn't even necessarily mean drugs that are like in the Controlled Drugs and Substances Act. You could be impaired by drugs that are sort of regular drugs that we're allowed to use, like caffeine. I've never had a caffeine case,
Oh,
but it's
interesting.
theoretically possible to be charged with impairment by caffeine or something that's legal that we use, to give ourselves energy.
What about the opposite if you're really sleepy?
So that would be captured under other provisions of the code. So you wouldn't be impaired by alcohol or a drug, but there are cases where people have been convicted of dangerous operation of a motor vehicle for driving at too great a level of fatigue to properly control a vehicle.
Yeah. And the second component of the test was this part of the 2018 change where it became within 2 hours of driving how they measure blood alcohol content?
Yes. So in 2018, the criminal code was like completely overhauled. They repealed all the sections related to impaired driving and wrote everything out fresh. And they changed it. It used to be that your breath samples had to be taken within 2 hours of the time you ceased driving, and they were presumed to be the same reading that you were at the time of driving, so long as a couple statutory prerequisites were met, including that 2 hour window. And if they were outside 2 hours, then the Crown could call an expert to relate your reading back to the time of driving by using scientific calculation known as back extrapolation. In 2018, they amended it to make the offense being at or over 80 within 2 hours after ceasing to operate a motor vehicle, and then to give the Crown the power to just add 5 milligrams of alcohol for every half hour that elapses outside those 2 hours. So eliminating the need for an expert and simplifying this question of the 2 hour window.
So the obvious question that gets asked is like, do they have to prove that you were driving, what your blood alcohol was at the time? Like, what if you can prove that you stopped driving, went into the bar, started drinking?
So this used to be known as like a post-driving consumption defense, and it came up a lot. And it was often used in cases where people like would flee an accident scene and go home and start pounding liquor so that they didn't
Is
get
it
in
a
trouble.
myth that it was a cop who did that caused this to be a big thing?
No, not only was that an actual case where his name is Monty Robinson. He was in an accident, somebody died. He went home, he started drinking, he came back to the accident scene with the bottle, drinking it in front of people, but he was convicted of obstruction for that because he knew what he was doing and he was obstructing the investigation. So it is a myth that people just got away with crimes when they did that.
Yeah.
What I find fascinating is that Monty Robinson is also one of the officers who was convicted of perjury in the Jajanski case. Um,
Okay, that was the Polish individual at YVR who was tasered, and then I think the RCMP completely lied about what happened.
yes. And so he ended up getting like a lengthy jail sentence for that. So I don't think he was the best police officer to begin with.
That's yeah. Is that unique to Canada, this 2 hours after?
Yes, yes.
Yeah.
I'm on the board of directors for the DUI Defense Lawyers Association, which is like an international organization of DUI lawyers. And yeah, the my American friends are shocked and appalled at this after issue because now like you can be charged criminally if you drink after driving in completely innocent circumstances. So if you go home and on your way home from work, you stop at the liquor store, you buy a bottle of wine, and maybe you have some sort of disability and you've got some balance issues, and somebody phones you in and says, "Oh, he was drunk." And then the police show up at your door and you provide breath samples, and you've just had that bottle of wine after getting home, you would end up charged. And then the burden falls on you to prove that you consumed alcohol after driving, that you had no reasonable expectation that you were going to be given a breath test, and that the amount that you consumed after driving matches the readings that the police got so that you weren't over 80 while you were driving. And that's
How do
all.
you prove that? Like, what are the common actual, like that was a question that we got asked was, what are the ways that you can fight DUI charges?
Well, I mean, to prove that, you would have to testify and explain, the circumstances and why there was no reason that you would think you were to be given a breath test. So, like, if you were fleeing the police or fleeing an accident scene, you're probably not going to win just on that basis. And then to prove the blood alcohol concentration component, you have to hire an expert witness to calculate your absorption and elimination rates and determine what your blood alcohol content would be. And that evidentiary shortcut that the Crown gets of adding for every half hour doesn't apply to the defense evidence. So you have to
Yeah.
pay out of pocket to prove your innocence in a criminal case, which makes it really hard. And in the 2018 amendments, the federal government removed so many of the defenses to impaired driving cases. So now it's very difficult to succeed in them. A lot of the defenses really come from successful charter applications for the exclusion of the breath test results or the blood test results or drug recognition evaluation or whichever form they're using to prove the impairment.
What would the charter argument be?
Oftentimes arguments related to Section 8, violations of the right to be free from unreasonable search and seizure, because the demand for you to provide samples was not made lawfully, or a lot of 10B violations. So people who weren't properly given their right to counsel. Those are the really big ones. Sometimes we're seeing kind of a trend right now in the courts where Section 10A, your right to be informed of your reason for your detention, is becoming sort of a little bit more popular, and judges are
Yeah.
accepting a lot of evidence for breaches of that. And they're characterizing it really as like a very simple requirement. Just tell somebody why they're detained. Like takes 2 seconds.
And one of the other things stemming from 2018 was the government increased the maximum penalty for a D or for impaired driving from, I think it was 2 years before or 5 years before to 10 years or more, which in the immigration world shifts it from being classified as general criminality to serious criminality that can lead to deportation. And it's a very stark difference, right? Like huge legal consequences. In the criminal defense world, had the notion of the seriousness of a DUI changed around then? Like, I don't remember it changing that much in the public discourse. It almost seemed to me like, because they did that at the same time that they legalized or decriminalized marijuana or legalized marijuana. And so I was like, well, Is it like they're giving with one and then being like, well, we got to be strict with the other? Like, what was going on in the criminal defense world at the time?
There was really nothing going on in the criminal defense world that warranted an increase in the penalties. We didn't have any like courts treating it as being less serious. The only thing really that was happening was that our governments were treating it less serious by sort of decriminalizing it, like we did in British Columbia for first-time offenders, and now, of course, we've seen that in Alberta, and to some extent, it happens in Ontario, Manitoba. Although different. So, but of course, those administrative prohibitions don't attract the immigration consequences.
Yeah.
So there was no need for the federal government to increase the sentence.
Did they explain ever why they did it?
No, and it was raised in, so I testified as an expert witness, both at the House of Commons and to the Senate about the Bill C-46. And it was raised in testimony by numerous individuals and experts who talked about the immigration consequences, and Parliament just did not care. It, it seems odd to me. But I think they also, at the same time, and maybe this speaks to their parliamentary intent, they eliminated one provision of the code that allowed people to get a conditional discharge for impaired driving offenses. So it used to be called a curative discharge. It had
Yeah.
to be by regulation in each province. It wasn't ever available in BC, but it was in Alberta. And you could essentially complete a treatment program if you were an alcoholic. As long as you completed that program, you would then get a discharge because you dealt with the underlying issue. And we try and reward people for addressing their mental health, not criminalize mental health
Yeah.
issues. But they removed that. So I guess that says their intention is that they want impaired driving to be viewed as serious criminality warranting a criminal record.
And deportation, I guess. So for a permanent resident, let's say they're driving along, um, and they may or may not be impaired. They're pulled over, they do the breathalyzer, they blow above 0.08. You'd mentioned that, first of all, what should they do at that point?
Well,
Like, let's say the police officer, actually, let's go back to the first. So, one of the questions, and this is one that I have because I don't really understand how this works as well, is that you'd mentioned that there's criminal charges and regulatory provisions for handling DUIs. What dictates which approach the police use?
it's officer discretion typically, although there are policies that govern how they exercise their discretion. So if it's an accident, and especially an accident involving injury or death, they're going to go criminal. They're supposed to go criminal. Although minor accidents in British Columbia are often done by way of administrative suspension, just because it's a lot more convenient. And then they look at your history. So if you have had previous impaired driving convictions or previous alcohol related prohibitions, they would exercise their discretion to proceed by way of a criminal code investigation as opposed to a roadside prohibition.
And as defense counsel, if you're interacting with someone, like let's say a permanent resident who's been charged criminally, which will have these immigration consequences, is it possible to shift from criminal to administrative once the process starts?
Yes, it is possible, and sometimes we see cases where a person is issued there's a different administrative prohibition that goes along with the criminal process, and at the end, maybe the readings are very low. The police officer decides just to issue them the administrative suspension that would correspond with the criminal case, but not forward charges to Crown.
Okay.
Um, so that does happen. But most of the time, if they've gone to the trouble of taking you back to the detachment and you're blowing above, 100 milligrams of alcohol and 100 milliliters of blood, you're going to get charged criminally. And then it's a matter of trying to use those negotiation tactics with Crown and the immigration consequences to find a plea outcome that doesn't result in a deportation proceeding.
And a specific question that I got asked was, can you wait for your lawyer before giving a breathalyzer?
So yes, but it depends. So for the roadside breathalyzer, no, you do not have a right to a lawyer prior to providing a sample into a roadside breathalyzer. But after that, once you're arrested, if they give you a demand for a further sample at the police station, then you have a right to speak to counsel prior to providing a sample there. But also, waiting for your lawyer means waiting for a phone call with your lawyer, not waiting for your lawyer to actually physically attend. That's not allowed in Canada.
So you can do the call, and if you continue to want to insist on waiting for your lawyer, is that an independent charge in of itself, or
Yes. So if you were roadside and you said, I'm not going to blow until I talk to a lawyer, you would be charged with refusal. I see those a lot because people don't understand the distinction between the roadside breathalyzer, where the right is suspended, and the police station breathalyzer, where you have that right. And then there are circumstances where maybe you want to call a lawyer that's not available, right? You know, I'm in
yeah,
Disneyland and you want to call me. Sorry, I'm busy.
yeah,
And in those circumstances, the police only have to wait sort of a reasonable amount of time for contact with counsel, and you have an obligation to be reasonably diligent in asserting your right to counsel. So you can't just say, I'm only going to talk to Kyla Lee. If Kyla's not available and not calling you back, you've got to either make another choice or blow.
yeah. And what are the consequences of the administrative prohibition as opposed to the criminal?
So in British Columbia, the roadside prohibition that you would get that's not alongside a criminal investigation is 90-day driving prohibition, 30-day vehicle impoundment, $500 fine, $250 license reinstatement fee, $31 short-term license administration fee, and then at the end of the 90 days, you also have to enroll in and complete the responsible driver program, which is like $930.
Are there similar, does the charter defenses and everything apply, whether there was a reasonable breathalyzer or no?
So in a refusal, you can use some of those arguments because the validity of the demand is a ground of review, but because it's administrative, and you as
Yeah,
an immigration lawyer, administrative law,
yeah,
it's you're really constrained by the statutory defenses. So you can adduce evidence to show that you weren't over 80, which is interesting because that's not a defense in a criminal case where you can't say, I only had 2 beers. You can challenge the reliability of the breathalyzer by saying, there was like mouth alcohol that affected it, or there was problem with the calibration. You get the calibration records disclosed to you. As far as charter issues, they really go to like the ultimate question of fairness. And if the evidence was obtained in a manifestly unfair manner, then the adjudicator can like give it no weight. But there have not been successful cases in British Columbia of people arguing the charter unfairness
yeah.
and their prohibition revoked. Happens a lot in Alberta, but not in BC.
Why do you think there's the difference?
Um, I think in BC, our adjudicators in that tribunal are less sort of forgiving. And in Alberta, the administrative scheme operates a little bit differently. There's in-person hearings. They're done over Zoom, but still, you can actually see people. There's more requirements for the evidence, including like video and photographs to be submitted. So adjudicators get a better picture than like a
Yeah.
template from a police officer and then some applicant saying a bunch of things that aren't included in that report.
Who are the adjudicators? Is it like just a purely political appointment or?
No, they're essentially delegated authority by the superintendent of motor vehicles. So there'll be a like a job posting, and anybody can apply
Okay.
for a job. There a lot of them are people with some sort of like law enforcement or legal background.
Yeah.
Some have law degrees but didn't practice or don't practice anymore. There was an adjudicator. I don't think he's there any longer, but he had a practice that didn't deal with anything driving related and then also did adjudication. But a lot of them are just like public servants that applied internally for the job and got it.
Interesting. So I'm still trying to figure. So like, does it vary detachment to detachment, municipality to municipality? Like, do you see trends in terms of whether it goes criminal versus administrative? No, just
No,
offense specific.
yeah, it really depends on the whether there's an accident and the history. And I will say though, like some places, if you have a history, you're more likely to get a second or a third or a fifth
Yeah.
IRP. Like Vancouver police, they almost never go crim code. But and RCMP are more likely to do criminal investigations, especially sort of in the north and in the Kootenays, if you have a history. So, but that usually tends to be a resource issue where those smaller locations weirdly have the resources to conduct the criminal investigation because everyone who's working has the same training to operate the instrument. Whereas in the bigger cities, you don't have a lot of people who are actually given that training to operate the instrument, and finding someone to
Huh.
do that
Yeah.
is a big problem.
Hmm. And in immigration, we come across DUIs like, well, I mean, there's a joke that immigration lawyers will make, which is that it seems that half of the United States is a DUI conviction. Um, and you're part of this international DUI lawyer association. I can't remember what you said the name of it was, but like, do you find that, first of all, like, do you find that, well, just how are the laws different? I know that in the States, there's so many, like, state by state, there's wet driving, reckless driving, DUI. Like, what have you found that your American colleagues comment on? Like, where have you noticed the differences being?
I mean, they would never have an administrative process like we have. That would be just a non-starter, completely unconstitutional there. But the biggest difference I think between us and the United States is that in almost all states, for your DUI trial, you can have a jury, and there is no restriction on what you can argue to the jury. So you can say, you know, if you want to persuade the jury that fairies came and messed up with the breathalyzer overnight, you can put that to the jury. Like
Yeah.
their restrictions, they're ethical things that they can say to a jury. Sometimes I'm shocked. I'm like, how can you just lie to a jury? And they're like, yeah, we're allowed to do that,
That's funny.
which is horrifying. Um, and in Canada, we're not allowed, like, we are not allowed to make any argument that, they call it the disconnect defense, that the person blew 200 milligrams of alcohol. They were well over the legal limit, totally intoxicated on paper, but they look sober, they act sober, they talk normally, they behave normally. Those two things don't connect, and that raises a reasonable doubt in the US. In Canada, those arguments are prohibited.
Huh.
We're not have our client testify and say, I drank three, 1 ounce tequila sodas, and then I waited 2 hours and I weighed 200 pounds and I wasn't over 80. Not allowed to make those arguments. Those are statutorily prohibited in the criminal code.
So they have more defenses. Am I wrong in thinking that they seem to convict more? I mean, obviously I only get exposed because as an immigration lawyer, I get contacted.
Yeah.
Do they actually get charged, do you think, more?
I think they get charged more. There's a lot more funding for DUI,
Mm,
where in the United States, like, gives money to police departments just for impaired driving enforcement. So they make a ton of money off doing it. And then the other reason that there's a lot more convictions is, like, population differences.
yeah.
So they have far more people, and far more police officers. So there's more investigations happening. And, even though you can run all of those great arguments, the state also has a lot of resources, and they'll call their experts and they'll pull out all the stops to prosecute people. So a lot of people in the US end up with just your, neighborhood criminal lawyer and not a
Yeah.
DUI specialist. And they end up getting convicted because they don't know better. And then they also have this problem in the US of, we kind of call them pump and dump lawyers.
Oh,
um,
tell me. I've never heard of it. Tell me.
yeah, it's or
I've heard of
dump.
it in stocks.
Yeah, dump truck is the other name. They're lawyers who will charge you $500 for your DUI, and they will go in and they will plead you guilty, and they'll get you some type of, like, a deferred prosecution
Mm,
or some conviction, but that doesn't have all of the consequences that you might face if you were convicted after trial. So they're called that because they're just pleading everybody guilty. And so people don't get informed about the immigration consequences, their Canadian travel issues, and then they realize after the fact, and then they're trying to fix it.
yeah. The other driving offense that I think is actually becoming, because DUI is doing equivalency of whether a foreign offense equates to a DUI is pretty straightforward, especially if there's a blood alcohol content test. I actually am not aware. I haven't seen it. I haven't seen any cases where someone like was declared criminally inadmissible to Canada where they were impaired and there's no breathalyzer. I'm sure it's happened. I just haven't seen it. What is increasingly becoming an issue is dangerous driving or offenses that equate to dangerous driving. Is that actually the term, or is it also like we don't have DUIs? Is there another term that the code uses?
Yes, so in Canada, the criminal code is dangerous operation of a conveyance, or dangerous driving, colloquially.
Yeah,
And then you would have in the US, you have all these different, like, alternative pleas like we have here. So you get like a reckless driving or wet reckless or
yeah,
criminally negligent driving, which obviously that would make you inadmissible. But
yeah.
Um, there's so many different characterizations of it that, when you do that type of plea in the US, it does complicate matters coming across the border.
So what is the standard for dangerous operation of a conveyance? But we'll just keep it to car. Dangerous operation of a car.
A marked departure from the standard of a reasonably prudent driver.
And what does that mean?
It's not a lot to constitute a marked departure. The Supreme Court of Canada, the most recent case from them is a case called Chung. It comes out of Vancouver. A guy speeds up going through the intersection at 49th and Oak. So he makes the yellow light and he goes 140 kilometers an hour through the intersection, hits another car, kills the driver. And he's convicted of dangerous operation ultimately by the Supreme Court of Canada, because the driving at that speed itself was a marked departure. Even though there's a Motor Vehicle Act offense for excessive speeding that would capture that conduct, it still itself is a marked departure. So the bar is very low. Basically, you violate a law deliberately, you engage in a marked departure.
When wouldn't it apply?
Well, there was a case out of Vancouver, although the Crown's appealed it, of a guy who ran a red light. There was no evidence of any speeding or erratic driving leading up to it. There was no evidence why he ran the red light. And he was acquitted because it seemed to be that the court was unable to distinguish that between a momentary lapse of attention. And so that's, driving exists on this spectrum where on the one hand you have perfect driving, on the other hand you have criminally negligent driving, and in between is all of the driving without due care and attention, the provincial offenses for momentary lapses of attention. And when a momentary lapse of attention crosses over into a marked departure, that becomes criminal.
Interesting. So if you were like, let's say, approached by an immigration lawyer, just an applicant saying, I was convicted for, speeding. My criminal record shows speeding. I was going 60 miles in a 55 zone, or I have a European conviction and it says that I operated a vehicle carelessly and caused an accident. What sort of things would you be looking for in the underlying facts to determine whether it would equate?
I mean, when I get these, I usually ask the client to send over any stipulations that were made, or admissions they made, if there's a sentencing decision, anything, any findings of fact, and then looking for, terms that are similar to Motor Vehicle Act terms in the legislation itself. So trying to align it, like careless. That's great because we have careless driving prohibited
Mhm.
Motor Vehicle Act statutes all over the country that you can equate them to. Whereas if there's words like dangerous or negligent, that's when you get into that's really more the criminal standard. So
Yeah. But what
we can,
about like with the speeding cases, if someone's saying, everyone was speeding or
yeah,
something
I
like
mean,
that, like when do
if
you like
yeah,
what yeah,
if everyone's speeding, then it's not a marked departure, right? Because you're saying everybody's doing it. Not everybody's going 140 kilometers an hour in a 50
down
zone.
Oak Street? Yeah.
Yeah, in rush hour traffic, approaching a yellow light. Yeah, like these, it's when you get into that behavior that I think the language used by the Supreme Court of Canada was that it would shock the conscience of the community, and it was pathological driving behavior. And that's when you kind of see okay, that's dangerous driving. But 60 in a 50 zone, 65 in a 50 zone, that's normal driving. That's
Generally fine.
for driving.
Yeah. Where does dangerous driving and criminal negligence? And is there criminal negligence of a operation of a motor vehicle? There is, or a conveyance.
So there's not criminal negligence operation of a motor vehicle as a de facto offense, but there's criminal negligence that involves operation of a motor vehicle, and there's provisions in the code related to criminal negligence causing bodily harm, causing death, and just criminal negligence simpliciter, where there are provisions that say that this can include out of the operation of a motor vehicle, and that's an even higher standard than dangerous driving. So you only see that in the most shocking cases. There's a case I dealt with on the appellate level, where the driving was sustained over I think about almost an hour, multiple civilian calls, driving wrong side of the road, driving onto the sidewalk, and eventually striking somebody and killing them.
It's interesting that that's higher because I like just listening to the two words of negligence versus dangerous driving. You'd think dangerous driving would be the more serious offense.
You would, and yeah, it definitely doesn't, it's not intuitive, but because the standard for criminal negligence is not just being drawn from driving offenses, but from all criminal negligence, that's why the standard is higher. And it's interesting because it previous to the amendments was considered sort of a more serious offense. But right now there's a case on reserve at the Supreme Court of Canada involving dangerous driving and criminal negligence causing death that led to a conviction. It's a question about the sentencing provisions, but one of the things that the court is really grappling with is whether or not the criminal negligence is actually a more serious offense since Parliament increased the
Oh,
consequences of
interesting.
dangerous driving because they now match.
Huh. And the other specific question, and you can always wonder if this is like an individual with an actual case. If it's an offense at a certain age to have zero alcohol, like to have anything above zero alcohol, is there a similar, I know that like if you have an N in British Columbia, I think you're not supposed to have any alcohol. Would that ever be criminal or is that always regulatory?
That would always be regulatory. So federally 0.08 or 80 milligrams percent is the standard. And so that's where you're going to get the criminal charges. That doesn't mean you can't be convicted of impaired with a lower blood alcohol concentration if there was some evidence to demonstrate that you were nevertheless impaired in your ability to operate a motor vehicle. And the degree of impairment is any degree, even slight.
Yeah. Um, as I mentioned, we now have ads on the podcast, so I'm going to take a quick break and we're back. Okay. It's the whole getting used to ads and saying that is a bit, it's going to take a while to get used to that. But so I want to focus a bit before we switch gears entirely on just the process again. So someone is arrested. Let's say they've called their lawyer and the Crown is going to proceed criminally. What are the steps in a criminal process and how long does everything normally take?
Well, I mean, the first stage obviously is your first court appearance. And then you would be obtaining disclosure usually after that. There's an electronic file transfer system for disclosure to be provided to your lawyer. And then, I mean, every lawyer deals with cases differently. Some just say, set it for trial, I'm not even going to bother negotiating. Some will do my approach, which is to read the file, identify any problematic issues, get information from the client about their personal circumstances, and then draft a letter to the Crown. I'm like kind of I've
Yeah.
heard a reputation for sending lengthy letters. I don't know if it's a good reputation, but so I'll usually send, something 15, 20 pages to the Crown, identifying all of the possible breaches, missing disclosure, frailties in the evidence, client circumstances, and pitching some sort of a non-criminal resolution.
So if a lawyer just sets it down for trial,
Mhm.
does that mean they don't plan on arguing anything before or plea bargaining?
Sometimes just the act of setting it for trial forces the Crown to take a hard look at the file and forces them to make decisions about whether they really want to run it. There are advantages to setting it down right away. And then, you can always plea bargain later. You secure an early trial date, so you're not coming up against Jordan issues. You also, securing an early trial date puts the fire to the feet of the Crown as far as getting you disclosure and conducting witness interviews and all of those steps. So like there's advantages to it. I always think more water under the bridge is better. It
Yeah.
gives them time to turn their lives around, do the things that you need to do to demonstrate that you're not going to be a continuing public safety risk. But there are some people who don't like to reveal their hand either, especially if they see a good defense. They'll sit on it, and then the morning of trial, they'll walk in and they'll say, "You can't prove this case, and here's why." And the Crown hasn't had any opportunity to really think critically about these issues because they haven't been told any of the problems. And so nothing's been fixed.
I assume most clients want, or yeah, most clients want it resolved as quickly and in their favor as possible.
Yes.
I would think, and I understand each lawyer might have different take, but I would think that presenting that in writing ahead of time would resolve it quicker than it sitting on someone all the way to a hearing.
Yes, and it's also like if you're paying a private retainer, it's a lot more expensive to take something to trial than to get an early resolution. And it's stressful for people. Like, the clients that I have that are going to trial are emailing me all the time talking about how heavily it's weighing on them. And that's, it's really hard to just kind of wait for that process to unfold, even if you do have a really strong defense. So, that's one of the reasons why I like my approach. I also think there are advantages in getting the Crown to be aware of all of the issues that might come up at trial, so that a better time estimate can be reached for trial, so that certain witnesses who might not otherwise be contemplated might be called to make full answer
Yeah.
defense. There's advantages and disadvantages to either approach.
And switching gears a bit completely, in the 20 odd minutes that we have left, I'm glad you mentioned Jordan, which is the principle or Supreme Court, I don't know if it's a rule or a principle, that trials or the process has to resolve within a certain amount of time, or I don't know if the case is stayed or just dismissed. Um,
Yeah,
and there's been a few high profile cases of this recently, including my law school crim defense, our criminal first year criminal law prof, who's now a judge in Ontario Justice Code, ripped the lack of judicial appointments. One in the past several months, a lot of my clients have expressed surprise at kind of the state of crime in general in Canada. And I know I've heard you speak to Mo Amir on This Is Van Color, kind of where he's asked similar questions. So maybe you can give your take as a crim defense lawyer. Like, kind of is there a crime crisis in Canada? Like, what is people I know visually walking around downtown, eyebrows can go up, but are things trending worse? Are the courts super underfunded and so everything's getting dismissed? A lot of new people to Canada, it seems like, I think, are hit visually and with stories in the paper and kind of wonder like what's going on.
See an increase in crime. I think there are concentrations of areas where crime is more likely to occur because there's a lack of mental health support, a
Yeah.
lack of housing. Like, I mean, this is the real problem is the lack of housing, the cost of living, the lack of supports for mental health and addiction, and the toxic drug crisis. And those are contributing to property crimes and crimes that are essentially motivated by people's mental illness, but it's not hugely increased over the previous years. Like if you actually look at the statistics about violent crime rates, they're not up much more than they were, before COVID. And people really are attributing this increase to looking at like 2020, 2021 rates.
Yeah,
But those years don't count. That was
yeah,
COVID, right? We didn't have people out and about and the same opportunity to commit crime. So there's no substantial difference. Um, and there is underfunding and under resourcing in the courts, especially here in the Lower Mainland. There's a big sheriff shortage, and you can't run a criminal trial without a sheriff in the room. Like it's just not allowed. Even if
What's
you
causing the shortage?
They lost a lot of sheriffs during COVID. People quit, people died, people retired, people went to police. A lot of sheriffs go into the sheriff job because they want to get law enforcement experience, but ultimately want to become police officers. And with the Surrey police
Mm.
hiring spree and Vancouver PD on a big hiring spree, they lost a lot of sheriffs to that, because it was easy to get a job in policing. So then they become quite short, and so we've had a lot of trials not go ahead just for lack of a sheriff.
Do you also notice the judge shortage? Is that as prominent as the and pronounced as the kind of the media makes it out to be?
I think it's worse in other provinces. In British Columbia, our BC Provincial Court, which deals with most crime, there are criminal offenses that are dealt with in Supreme Court, but the BC Provincial Court is great about publishing a monthly report on the judicial complement, and you can find it on their website. They have a benchmark from 2005 of when they had a full complement of judges and things were great. And then it dropped down and there were no appointments, and it slowly increased, and it's actually at the highest it's been for the number of sitting full-time judges in British Columbia in the last, I want to say, 5 or 7 years as of April 30th. So provincial court in British Columbia is actually doing really, really well on
Minus
just
the sheriffs.
minus the sheriffs. Yeah. Judges
So
and
it's
the
interesting because I've never read that. Like I've never heard that component of it, that it's you always hear about the judges.
yeah.
Um,
And then there's also a shortage of like court clerks, registry staff. So people who actually run all of the equipment and make the court function, there's a shortage for people in those roles as well.
yeah. Have they moved anything else from criminal to admin? I know there's a lot of civil forfeiture, but that doesn't really, I don't think it's exactly an administrative offense. That's a whole separate thing. But is there anything else like when the DU, when they said, okay, DUIs are now going to be administrative, were you concerned that, okay, next up, dangerous driving, administrative, robbery, admit, like was there
Um,
concern that this could spread
no,
just
I
to
don't,
save
I don't
funds?
Yeah, I don't think there was a big concern that it was going to spread because you can't really get away with it as a provincial government, like decriminalizing things, unless it squarely fits in with an area of provincial jurisdiction. So when that law was introduced back in September 2010, there was a constitutional challenge, and one of the arguments in the constitutional challenge was that it was ultra vires the powers of the province because it was essentially enacting criminal law. And the court dismissed that because it's road and highway safety, right? It's squarely within provincial jurisdiction. But it's really hard to put robbery
Yeah,
or
yeah, yeah.
property crime offenses as within provincial jurisdiction. I mean, I guess theoretically you could say it's property and civil rights in the province, but again, that would really more be like creating the civil resolution tribunal so you can sue the people who broke into your house, not
Yeah.
not dealing with those charges in a different way.
And dangerous driving already has kind of similar provisions.
Yes. I mean, dangerous driving can fall into any provision under the Motor Vehicle Act. And then we also have in BC administrative driving suspension. So there's like a high risk driving suspension, which can
Mhm.
be by police report of high risk driving
Yeah.
behavior.
If you speed above, what is it, 20 or 30 or 40 over, it's an immediate impounding of the car. I'm always cautious when I'm near
Right.
that level. Not that I speed, but yeah, when I do, I always am cautious that like, uh-oh, I'm hitting that
Yeah.
hitting.
So 40 over, you're going to get your car impounded first time for 7 days, second time for 30 days. And if you go more than 60 over, then the fine increases on top of that.
And yeah, that's so like, yeah, just the different classifications of how stuff goes crim to admin, obviously as an administrative lawyer. Actually, one thing we've talked, so what is the worst consequence for the administrative penalty? There's no jail time for it, right? Like that would
No.
keep it in under crim.
Yes. Although, like, if you were to be convicted of a motor vehicle act driving offense, you could get jail time for that, up to 6 months under the Provincial Offense Act. But then that's not administrative; it's just a provincial offense.
Yeah. And I think actually possibly last question. Do you notice trends in what the police are charging? Like we'll often say in immigration, oh, this seems to be the flavor of the month, the flavor of the year. What are some of the things like what are the flavor of the trend flavors?
Oh yeah, I mean trends for sure, especially in driving enforcement. Like as soon as the weather gets nice, like it's May now, so we have speed enforcement month because everybody's, there's a nice long weekend, a lot of travel, people are getting into their summer, especially for university students. So there's a lot of enforcement action taken on speeding. In the rainier months, we see trends for a lot more hit and run related investigations and
Interesting. Why would that be weather dependent?
there's more accidents in the rain. It's harder to see people.
Oh, okay.
And also, people tend to drink more and then drive home in rainy or darker months because you're depressed. So you drink and then you go out
Do you
and
get
you
more
don't.
calls after Canucks games? Because
Yes.
those are often depressing. So
Yeah.
you get the
I'm,
double
I'm,
whammy.
I'm rooting for us to make a full playoff run. Professionally, it's great for me. Yes, Canucks games are a big one. The fireworks, like the celebration of light that we have, that's always big. Super Bowl, but not Halloween or New Year's Eve. Those are usually not very busy, but Thanksgiving is
Why is
big.
Halloween or New Year's not busy? I would have thought that would be super busy.
People plan
People
ahead.
get a costume on and they just like, oh, I'm someone else.
Yeah,
No?
They plan ahead, I think. I mean, Halloween, you get a lot of people committing like dumb property crime. They're
Uh,
they break stuff, but for driving offenses, they usually make arrangements in advance because they anticipate there's going to be enforcement. But Thanksgiving, you go to Thanksgiving dinner with your friends and they're pouring you wine and you're not keeping
yeah,
track
yeah.
and you don't think, and then you drive home. So
I
I
do
get
the
a
question I often have, is it all right, there's all these scenarios that now like come to mind. So you're driving and you see a roadblock, um, and you're drunk. This doesn't happen to me because I don't drink, but like you're driving and you see a roadblock and two or three intersections before, if it's possible, you turn to avoid it. Are the
Mhm.
police normally watching for stuff like that? Like, do they have officers often in like random
Yes.
corners? Yeah.
Yeah.
I've seen it where like they're on the, like sometimes you'll be driving and you'll see an officer yelling into a phone and you're like, who are they talking to? I don't see anyone.
Probably their wife. Um, yeah, at roadblocks, they will have officers who are tasked with the role of spotting people who turn off. They try and strategically place them where by the time you see the roadblock, you have no other choice.
Yeah.
But they do put it in a location where there are side streets. They will have people positioned down those streets. They will have spotters to look for it, cars waiting nearby to go and investigate those people. So if you're turning off in front of a roadblock, you are going to get pulled over and investigated for sobriety.
Yeah. I've always wondered when you see like speeding blocks or roadblocks or police sitting on like a road that's rush hour and you're just like, oh, it's impossible to speed even if I like want to. I don't know why they're all here.
They are doing
Um,
distracted driving
so
enforcement.
that was going to be my next question is when does distracted driving rise to criminal or does it ever rise to criminal?
It does. There's a case out
Interesting.
of Victoria where somebody was they were doing a number of things at the same time, and they were texting while driving, like in motion, not just the courteous red light text. Um, and they were in a school zone. They were speeding in the school zone, and there was a crosswalk and a kid in the crosswalk, and they did not stop. And
Uh,
yeah, so they
you
got
actually had your TikTok. When I got TikTok, one of the first videos that popped up was this really funny video that you did where you were like in a car. I don't remember what music was playing, but it was like, no, the phone can be not there. Yes, it can be here. And it's just stuck with me so much because I'm always like, oh, the phone is down there. Like, is that going to get me? Like, how does that actually? I mean, I know that that video is accurate, but like, how do the police, how often does that happen where like the phone is just, it's by your lap, but you're not using it or that distracted
more
driving is,
Yeah,
it does?
more often than it should, the police are issuing tickets for people who have the phone loose in the vehicle. That's because that used to be their interpretation of the legislation. As long as the phone was there, it had to be mounted. It couldn't be sitting on the passenger seat or sitting in the cup holder. I took a case to BC Supreme Court on that and succeeded and got the clarification that no, you can have the phone loose in the vehicle. That's not the offense. The offense is actually interacting with the phone, or touching the phone in some way.
And what are you allowed to do with the mountain phone? The like, can you be flipping through podcasts? No.
So once your phone is mounted, you are only allowed one touch, and that one touch is only allowed for the purposes of ending, accepting, or declining a call.
Interesting. Is it true that sometimes when you see what you think are just people asking for change, walking up and down an intersection, that they're undercover police officers?
Yes, police will dress up like people who are begging, or those window washer people. They will dress up in civilian clothes and pretend to be on phone calls while peering in windows. There've even been cases of police officers getting in like cherry pickers and pretending to be construction workers and then peering in windows from atop the cherry pickers.
Wow. Wow. That's huh.
Yeah, so just don't
It's
touch
there's
the
so
call.
much what are some of the like what are the actually this will be my last question. What are some of the live issues about like where there is uncertainty in the law, cases that I know you have a YouTube channel called Cases That Didn't Go to the Supreme Court. But like what are some of the unresolved big unknowns or controversies with the state of any driving offenses?
I mean, probably with distracted driving, there's the most amount of sort of unresolved issues because the technology has advanced to such a point that the
Mm,
legislation is basically outdated. It doesn't address voice commands, for example. Like if you, I can tell my phone to do anything, and if it's not mounted and I'm giving it a voice command, is that really distracted driving? Technically, I'm interacting with the fittings of the equipment, but I'm not touching it.
And all the
But
cars have these huge screens now.
yes, the big
Uh,
screen vehicles and whether those are a distraction and what you're allowed to do with respect to those. So there's a lot in relation to distracted driving that we don't know. As far as impaired driving, there's still like a lot to be litigated about the amendments to the criminal code, particularly in relation to certain disclosure obligations that the Crown has and what that actually looks like. It's really technical, but they have to show that the instrument registered a zero reading before you provided a sample. It's called a blank test. And the zero reading is truncated in the instrument. So it'll mask anything that's above a certain that's below a certain threshold. So a zero isn't actually a
mm,
zero. And so the question is whether or not they can prove that there was a zero reading, and whether disclosure of the non-true zero is sufficient to meet that obligation.
huh.
That.
Do you expect we'll ever go like some countries where it's just pure 0.0?
uh, I hope not. I don't think that I don't think that that's scientifically sound. I don't think there's any good support for that. And there even is some research that suggests that up to 20 milligrams of alcohol, you're a better driver. There's a lot of
Interesting.
studies that have been done that show that your driving skills actually increase a little bit with a small amount of alcohol in your body. So I don't know, let's just legislate 20 milligrams of alcohol in your
Yeah,
body.
it that'll make the DUI world for immigration interesting. This has been fun.
Thank you.
We'll definitely have to have you back on. Like I have so many criminal questions. Deanna always says that, oh, and for those wondering, Deanna is in court today, but Deanna always says, oh, Steve, you always have question after question whenever you get a criminal defense lawyer or any lawyer on. And there's so, all the areas of law, they're just so interesting and so many little issues. Yeah, this was fun.
Thank you so much for having me.